The court has not distinguished those, and I don't think it should. Religiously based moral commitments are a religious practice. And if you go back to the beginnings of religious liberty in America, there was much less regulation. We were much less religiously diverse, so there weren't nearly so many of these issues. But the issues there were very much included moral teachings and moral practices. So the Quakers were exempted from swearing oaths. They were exempted from serving in the militia, although they sometimes had to perform alternative service or pay a commutation fee. Jews in Rhode Island were exempted from the incest laws to the extent that the Jewish marriage laws differed from the Christian marriage laws. From the very beginnings of religious liberty in America, the right to follow your religious conscience was part of what was protected. The first exemption from swearing oaths is 1669 in the Carolina colonies. This goes back to very early on. The first exemption from serving in the militia is 1673. So it has to be included. And at the other end of the continuum, the court has not distinguished this kind of claim from the worship service itself, right? So Smith was about the worship service. Case in 1997, City of Bernie v. Flores was about the right to build a place of worship. There's a 2006 case, another small group that was using a mildly hallucinogenic drug in its worship services. And in Smith, when Scalia is giving examples of what's not protected, he runs together worship services with everything else. He says ceremonial use of bread and wine is a religious practice that can be regulated, can't be exempted. So at either end of the continuum, I think the court is treated as the same, and I think they were right to treat it as the same.